Welcome, everyone. I'm Bassem Fawzi, Vice President, Middle East North Africa at Alexis Wealth. But above all, I'm a Canadian wealth manager, passionate about helping expats navigate financial, tax, and estate planning with confidence. But first of all, let me take a moment to apologize for the delay. That was just had a bit of a technical difficulty, but we're over it now. So estate planning is something that we often push aside, thinking we'll get it later. But for those of us with assets and loved ones in different countries, waiting isn't an option. Having a plan is a key. Over the years, I've worked with expats to protect their wealth, minimize their taxes, and ensure their legacy is preserved. I'm dedicated to bringing you the best Canadian and cross-border experts to share valuable insights. In our last event, we welcomed Ruby Sean, a cross-border tax advisor, and will continue to bring you specialists who can help you make informed financial decisions. Next time, I'll be hosting a Canadian mortgage specialist to ensure and explore financing options for your Canadian mortgages. But for tonight, and without further ado, I'm excited to introduce two highly experienced estate lawyers from Canada, UK, UAE, who will be sharing their expertise on how Canadian and UAE estate laws impact your wealth, the biggest mistakes expats make with wills and assets transfer. I appreciate you being here, and I'm looking forward to a great discussion. And let's get started. So tonight I'd like to welcome Alia Khan. And Alia is an Ontario-based estate lawyer specializing in estate dispute and wealth protection. Then you have yours truly. And unfortunately, we don't have with us tonight Andre, who's a founder and principal of AS Legal, and he's got more than 20 years experience in multi-jurisdiction estate planning. And last but not least, UK and UAE-based estate and trust foundation lawyer specializing in cross-border asset structuring and legacy planning, Mr. Ali Khan. So when we were putting our work together, we looked at the questions that you submitted to us previously, and we were very happy to see that 75% of today's attendees sent in their questions before the webinar. Now, due to time constraints and the personal nature of many questions, we have grouped the common themes and built tonight's webinar around them. At the end of the webinar, if you still have questions, let us know in the post-webinar survey, and I will personally reach out to you. Some questions were in a very personal and individual nature, so we will not be able to give a blanket answer to a lot of those questions, but we're happy to address them afterwards. And also, as a thank you for being here this evening with us, at the end of the survey, at the end of the webinar, actually probably by tomorrow, you will receive a survey. And as a thank you for taking your time to fill out the survey, you'll have the option to download an estate planning checklist. It's downloadable. You download it, you fill it for your record. We don't keep record for it. You just simply just go download it, save it, and fill it up at your leisure. So why estate planning is a critical part of wealth management? Estate planning is not about the will. We hear many clients come to talk to us, and when we go through the estate planning part, they say, yeah, I have a will, or yeah, I need to get to draft a will, and many things around this line. But the fact is, a will is not the estate planning. Estate planning is about wealth preservation, tax efficiency, and smooth transition across generations. Many Canadian expats own assets in multiple countries, at least here in the UAE and in Canada, and some of my other clients, they own assets in different countries, like Egypt, for example. So cross-border complexities require financial and legal alignment. And tonight is about this alignment to see how we work together to help you cross that barrier of understanding the importance and how to get to proper estate planning or estate plan or financial plan. Key financial concern for expats, that's what my clients tell me, they want to ensure the liquidity for dependents after their passing and minimize estate taxes across different jurisdictions. For a simpler case here, UAE and Canada, and structuring assets to avoid probate delays and unnecessary legal cost. So as a wealth manager and a financial planner, we have our perspective on that topic. And I can sum it up and I say a well-structured estate plan is the foundation of a long-term wealth preservation. It's not just about assets, it's about your legacy. We work, we accumulate, and those assets will be passed on at some point or another. So we need to structure that properly and get it done properly. So from a wealth manager's perspective on estate planning, as a wealth manager, again, my role goes beyond just managing the investments. It's about ensuring that the client financial legacies are protected and efficiently transferred. So my perspective on why estate planning is a critical part of your wealth management, it's about the protection, it's about the tax efficiency, and about the multi-jurisdictional planning for expats. And the role of legal and financial coordination, and this when we are working together, estate planning requires, it's a team approach. So my esteemed guests tonight, the estate lawyers, ensure all documents are done properly and strategically and legally enforceable. Then we have our tax advisors to structure wealth for efficiency. Wealth managers align investment to support the legacy goals. Estate planning is not just for the ultra-wealthy. It's for anyone with assets, children, family, business, and do you want to ensure the financial security for the family, for the next generation? That's where that's where estate planning comes into play. So the role of financial planning in cross-border estate planning, there is a relationship between the financial planner, tax advisors, estate lawyers, and cross-border estate planning. Each professional plays a distinct role, but we collaborate at the end of the day for a comprehensive estate strategy. Financial planners focus on wealth structuring, retirement, and cross-border coordination. Tax advisor handle tax optimization, compliance, and reporting across jurisdictions. Estate lawyers ensure the legal documents and asset protection strategies align with local and international law. So finally, why estate planning matters? For wealth preservation, tax efficiency, and smooth transition. Canadian expats face multi-jurisdictional assets challenge. Key concerns, again, liquidity, minimizing taxes, and avoid probate delays. I don't want to repeat this part again. And from here, I'm going to turn it over to Alia Khan, Canadian Legal System, Canadian Insight Estate Planning Challenges. And over to you, Alia. You're on mute.
Sorry, I was muted. I said, hi, everyone. I know it is the evening for you guys over there. I think you're just after 8 p.m., but for me, it is 12 in the afternoon, and I am still sipping on my morning coffee. So I'm going to talk to you guys a little bit about estate planning, why it's important for you, some of the challenges you might face, and maybe some key factors that you can consider when you're trying to pick out a lawyer to help you navigate this really complex situation, okay? So let's get into just a couple of things here. There are some slides in the background. Bassem, do you want to go to the next slide?
Yep.
Okay, so what happens if you have no will? I'm guessing that a lot of you there may not have a Canadian will, and you're wondering what would happen in that scenario. Okay, so I can let you know that in Canada, we have what's called the Succession Law Reform Act. So there's legislation that's going to govern, and that legislation will determine where your wealth is going to go. Okay, I know there's a big myth around, oh, they'll give it to the government. That's not true. It's not what happens. Okay. So if you have a spouse and children, then they're going to give 200,000 to your spouse, and the rest is going to be divided amongst your children. If you pass away and you have no spouse, but you have children, then they're going to divide it between your children. The law is so detailed. It goes all the way down. Like they have considered many scenarios. So no spouse, no children, no spouse, no children, no parents, no spouse, no children, no parents, no siblings. The law goes pretty far down, and they will locate any relative possible to give your wealth to. It would only be where they find no even distant relative, that then they would be in a situation where they didn't know what to do with your wealth. Now, I know there's some differences between how Canada would regulate this and how the UAE would regulate this. And my understanding is that in the UAE, you guys might have some Sharia law there. In Canada, there is no Sharia law. So if that is something that you are interested in, and that is the way that you want your estate to be passed down, that's going to require you to take some steps. Okay. You're going to have to get in contact with an estate planning lawyer in Canada, and you're going to have to set up a scheme that makes sure that the transfer of wealth in Canada happens according to those rules. Okay. And that can be done. That's something that happens here all the time. They would create a structure for you to make sure that the transfer takes place in that way. Okay. So we can create structures here that mimic Sharia law. We can go to the next slide. Okay, so what happens if you have an international will? You have wills maybe in the UK, or you have wills maybe in the UAE. What's Canada going to do about that? So it's really going to depend on whether that will also satisfies the Canadian laws. In Canada, each province has their own set of rules for what makes a valid will, just to complicate it for you a little bit more. So make sure the lawyer you're talking to knows which province you're considered with, which province you own assets in, and they know the probate laws in that jurisdiction, okay? You theoretically could have a will, an international will that satisfies the Canadian rules and therefore would be valid here. Now, is that something you want? Is another question, okay? I don't just draft wills, I also litigate wills and take them to court and appoint executors. So that gives me a little bit of a different understanding of the situation here. So while, yeah, okay, legally you've checked all your boxes and legally this is a valid will, you still may wind up in a really complicated situation. Because in Canada, the court requires wet ink on a will for that to be valid and for you to be able to appoint an executor, which is something you're going to need to do, which is something that's going to have to happen. Now, if that piece of paper will is hanging out in the UK or is hanging out in the UAE, now you're in a complicated situation. I don't know if the UAE requires the wet ink, right? And if they do, if you can't get that will over to Canada, now you have to bring a motion, you have to go appear before the court, you have to convince a judge that, you know, this scenario is fine and they should approve it, which in the end is likely going to work out, but you've now spent a year and $20,000 trying to fix a situation that you could have just corrected, you know, years before with some good planning and some good foresight. Okay, so that's something that you just need to think about. So my recommendation would be make sure you have a valid will in Canada, regardless of whether it's you have one somewhere in another jurisdiction. Okay, Bassem, we can go to the next slide.
Done. That's done.
Okay, so your Estate in Canada includes all of the assets that you own upon death. Okay. You might have some real estate, you might have some investment accounts, yeah, some bank accounts, savings accounts, whatever it is that you hold in Canada. All of that makes up your estate upon your death. Okay. The will is only one structure that you can use to transfer wealth. The whole goal is to take everything that you own before you pass away and get it into the hands of the people you want to get it into in the way you want to get it into their hands with the least amount of tax and sometimes the least amount of time and cost as well. Okay. So there are other tools that you could use to transfer the wealth into those hands. Those tools include wills. I saw in the questions that you guys all put up before the webinar, a lot of people were asking questions about trust. So it seems like you're already starting to think about what are some of the other structures that you could possibly transfer wealth with. And yes, trust is one of the options that is available to you, but whether that's going to work for you is really going to depend on what assets it is you're trying to transfer, how old the people are you're trying to transfer them to, the level of savviness of the people you're trying to send them to. And there's also some tax implications there as well, because trusts are taxed in Canada. So that may not be the most beneficial way to transfer the wealth as well. Corporations are another vehicle that you could use to transfer wealth from one generation to the next. Corporations can own real property in Canada. So it may be and by real property, I mean like houses, condos, they can own property, okay? So that might be an option worth investigating. Is a corporation a reasonable way to transfer the wealth? You might be able to avoid some taxes. You might be able to avoid some probate. But as you can tell, there are so many options, and each option really depends on the specific makeup of your situation. Awesome. We can move on to the next slide. So what does it mean? It depends on your situation. So there's a few factors that you and your estate planning lawyer are going to want to sit down and talk about to figure out which of those structures might be reasonable to use. Okay. And it's really going to depend on the goals that you have. So you heard me say earlier that if you only have an international will, that there may be a time lag, right? Maybe having funds available immediately is something that is really important to you. So that's going to factor into the type of structure that you use to transfer your wealth, right? Because, applying for an estate executor and getting approval and getting these things take time. Right. So how are we going to make funds immediately available so that the people that are getting the wealth can fund whatever it is they need to fund in the meantime before the entire transfer takes place, right? Like that's only one consideration. Then other considerations could be tax minimization, right? Like what's really going on here? That's going to depend on what is owned, how it's owned, and who it's being transferred to. I just want to see what the next slide is here. Give me 1 second. Sure. So Bassem, you can go to the next slide. So, and the reason why I'm saying each of these scenarios is really different, and who are the beneficiaries? Where do they live? Okay, who is the executor? Where does the executor live? And the people who own the wealth, who are they and what do they live? Okay, in Canada, there are some super specialized and extra taxes for people who are non-resident in Canada. Okay. An estate is considered to be person almost in Canada. Okay. Meaning it's subject to taxes as if it were that person. Okay. Which also means that whoever the executor is, so the executor is the actual person who's going to go to the bank, who's going to sign the real estate documents, who's going to actually carry out the wishes of the person who's passing on the wealth. It's a big job. Okay. It's also a job that they get paid for in Canada. They get paid according to legislation. They get a percentage of the wealth, right? Because it is a job that has a lot of tasks involved in it. But where that person who's going to do that job is really matters. You know, we live in a world where a lot of stuff you can do it digitally. You don't need to physically be in Canada. You could be anywhere in the world. Well, that's allowed. You can have that. But now you're in a different scenario tax wise. Because in Canada, typically, unless you, again, bring a motion, which is going to cost you lots of money and take lots of time, and you're going to have to convince a judge, okay? Usually, if an executor lives international, then that's considered to be a non-resident estate. Okay. And now you're subject to the extra non-resident taxes and non-resident rules. One of those non-resident, there's many of them, but just for example, one of those non-resident rules is that the court requires that a foreign, so a non-resident executor, pay a bond into the court before he can receive his certificate of executorship. And that certificate is like the holy grail for executors. He cannot take any steps. No funds will be available. No property can be transferred. No investments can be rolled over. Nothing can happen until that certificate is received. So now imagine you have a foreign executor trying to be appointed as your executor for your assets that are in Canada. And they're asking him, well, you need to now pay us double or equal to the value of the assets in Canada before we're going to give you that piece of paper. That's what happens when the executor is non-resident in Canada. Okay, so there's companies in Canada that will do it, or maybe that's not a big deal for you. Maybe that's something that can happen. So, and maybe you trust that person so much you really want them. Like we don't really know. It's really going to depend on the specifics of your situation before we can know what's going to happen here. And it may also impact the plans that you have within your own family, because where the beneficiaries are at the time that they inherit also has an impact on the withholding taxes for the estate. So though they're all really important factors that you need to consider when you're determining what you're going to do and how you're going to plan this out. And it may be that once we dig deep into some of these factors here, that you start to figure out which of the structures that I talked about earlier, if you'll remember, there were wills, there were trusts, there was corporations. Now we're starting to uncover some of the reasoning that's going to help us figure out which of these structures are most viable for you and which should be used in conjunction with the foreign estate planning lawyers and your foreign investment planners. They can all work together to come up with a structure that works across all your assets to ensure all of them are protected and that all of them meet your goals of transfer, right? Whether it be tax avoidance or immediate transfer, whatever those goals may be, okay? I believe I have one more slide, Bassem, if you want to go there, which means I'm almost done talking. You don't have to listen to me bore you any longer after this. So, okay, here are some more factors that you need to consider, okay? Because there are some ways that you can remove assets from your estate entirely, okay? Meaning they pass immediately to your beneficiary upon death. The death is the action that enables the transfer. So no other steps are required. You don't have to go to the court. You don't have to get that certificate. You don't have to do that. It's not on all assets. There's very few assets that it's on. But if you own some of those assets, we need to make sure that they aren't going to go into your estate by mistake, right? This is one of the ways in which we can have funds immediately available to people. So we need to factor that in and plan that in. And you also bypass the probate tax as well. So it's a really important thing that needs to be investigated. But it obviously, again, it depends on age, it depends on who they are, it depends on how it wants to be divided, it depends on where they live. There's a number of factors that need to be considered before you can make use of this tool of transfer. It is a tool that allows funds available right away, but we need to make sure that we can use it and that we can use it properly and that it's not going to have any negative consequences or delay for the people that need to get the money into their hands immediately. It may be that you have Canadian relationships that you can leverage in this situation and lean on and depend on to make some of your estate planning uh, happen the way that you want it to happen. I believe that that was all I had planned for today. I'm going to pass it on to Ali and hear what he has to say.
Thank you, Alia. Thanks a lot.
Hi guys. Just checking you can hear me as I've got these headphones
Yes,
on.
yes,
Everyone hear me okay?
clear,
Fantastic,
yes.
excellent.
Thanks, Alia.
Well, firstly, thank you so much everyone for attending today. I know it's probably not the most enthralling thing to listen to on a Thursday evening in a sunny Dubai. It's certainly the most enthralling thing I could be talking about at about 4:30 in the afternoon in the UK in London, where I am right now. And guess what? It's now sleeting and hailing outside, so enjoy the
Oh,
sunshine whilst you have it. Um, so it's a relatively recent thing in the evolution of the United Arab Emirates that you have an expat community that are thinking about things like estate planning. Throughout at least my experience in the UAE, spending a bit of time there since I was born. Um, the traditional idea was, you go to the UAE, you do your time, and then you head back to wherever you're from. And increasingly now, there is, as we all know, a brand new environment where people are looking to stay there and settle there and have roots there. And then people think about the future and the legacy that they're leaving. And that comes with all sorts of complexities and issues between assets they may hold and interests they may have in their home jurisdictions and those sitting in the UAE. So the way we tend to approach this in general is to say primarily the lawyers we work with or the structuring folks we work with in your home jurisdiction tend to take the lead when it comes to looking at the complexities of things like tax, looking at the complexities of things like legacy. So, for example, in this scenario, we would work with Alia. Alia would take a lead, say, okay, well, these are the complexities that we have vis-a-vis being a Canadian citizen and having assets there and having a legacy there. And we would plug in to see how that would work from a UAE perspective. The UA perspective being more fresher. It's newer. There's a growing number of complexities, but there's still not as many as the home jurisdiction. Some of those complexities are actually quite basic to deal with. There is a very clear thing to be aware of in the UAE that makes a big difference if you're Muslim or not Muslim. It might sound odd from the perspective of those who come from other jurisdictions, but in the UAE, that is a material consideration. So let's take the example of an individual who is from a Muslim background, has spent a lot of time in the UAE, built their career there, etc., and then gets to a point in time where sadly, they pass away quite early and have young kids. Unbeknownst to them, as they're Muslim, the Sharia courts, the courts on the onshore UAE jurisdiction will apply Sharia law in terms of intestacy over their children. And if anyone is interested in what type of Sharia is applied, which madhab, which school, generally speaking, it's a mixture of Maliki and Hanbali, and it's certainly not Jafri. If any of the folks on this call are from a Shia background and are wondering whether that would be applied. What that brings about is thinking to say traditionally, one would do what they can to ensure that assets that are located in the UAE are either dealt with or managed or dissipated in a manner that allows for them to be protected under a will that sits in their home jurisdiction, unless it so happens that they do want to apply that Sharia law to it. So the complexity of a Muslim testator would be different to a non-Muslim. It would be something that we would work with the particular testator that comes along and look at mechanisms and ways that are entirely bespoke to their scenario and situation and their wishes. And it's certainly something which requires a little bit more than just a 5-minute sort of segment on. But what I can talk about is new things that have popped up in the UAE specifically for non-Muslims. And I'm sure everyone here has heard about the capacity to register a will in the common law jurisdictions. I'm going to focus on the DIFC in particular. The DIFC in particular is, as you may or may not know, a common law island like the ADGM in Abu Dhabi, the DIFC in Dubai. They're common law islands. It is not as clear cut as saying common law completely applies there, or English law completely applies there, or Canadian law, or those jurisdictions in Canada that apply common law directly applies there. But what it does allow for are common law ideas of things like trusts and probate, etc. And so it means that non-Muslims have been able to register a will in the DIFC, and the DIFC essentially takes precedence over even the onshore courts to make sure that the assets are distributed as per the will of the testator. That, of course, again, is for non-Muslims in particular. So what happens if, for example, you have assets in the UAE and assets in, say, Canada, and you're non-Muslim? Generally speaking, you would look to make sure that the provisions of the wills on both sides are as aligned as possible to ensure that any executors working on it can work in tandem in the future. One of the things to be aware of is of course, that guardianship and the idea of who is deemed to be a minor is in the UAE age of 21, which differs from a lot of home jurisdictions. So, for example, if you're assuming that somebody has reached the age of 18 and that therefore reached the age of majority, just be aware that that might be slightly different, and indeed is different when it comes to the United Arab Emirates. Usually what tends to happen is there's a will that is drafted elsewhere. It is looking to be enforced against assets in the UAE. For the purposes of this example, the testator isn't Muslim, and you get a circumstance where you're looking to say, okay, well, can I enforce this? That requires quite a careful process and has not been necessarily without peril. In the UAE, it can be quite difficult, and it's a fresh process that has started. It is something that we have worked on. The difference being that if the will has got a writ or probate, as Alia was mentioning earlier, such that the courts have essentially said in somewhere like Canada, yep, this is something that can be enforceable, then one would have to go and directly enforce it in the UAE courts. That's relevant in certain circumstances. But what we're finding is trying to make sure that there is a view of all the different scenarios that can happen with one's will, and all the different bases are covered to as high a level as is possible. Is the aim of actually engaging structuring lawyers in the first place. The only other aspect before moving on to the next slide that I would go into is when it comes to rumors that have been heard, I know across the UAE that the ADGM now allows for allows for Muslims to apply common law wills. As is a nuance of the UAE, often you'll find practices taking place without the capacity to go directly to a decree or a law to state whether things are permissible or not. We have a good relationship with the AGM. We've heard varying things about it. If somebody is insistent on finding it out, we can carry on to find that out. Our general approach has been, unless there is a law there to enforce a right, it's very difficult to rely on it, especially if you're dealing with something as sensitive as your estate. And there may well be a better solution anyway, with the benefit of speaking to folks like Alia and Basim and myself. There may be some in this call who are looking at crypto virtual assets as part of their legacy. Anyone who deals or works with crypto, it's one of my main practices areas, will understand that it is an ever-evolving environment full of a number of different things to think about. The DIFC has tried to provide an estate planning solution such that you can now register a virtual asset will with the wills registrar in the DIFC. And what they do is they have a self-custody wallet that allows for your crypto to essentially be held in a particular safe space with particular, a bit like a multi-access wallet, particular permissions given to particular individuals. It is brand new, it's fresh, it's only a few months old. So again, tread with it carefully, but it is available for those who want to look into it, and is often it's certainly from my experience, one of the more secure ways to be able to ensure that any crypto in your estate is passed out as per your wishes and your estate. If you're trying to do that in England and Wales, for example, I know that there's a number of complexities that are trying to be dealt with in terms of, okay, well, what is the asset? What is property? Is Bitcoin, property? And you'll end up spending quite a bit of time and money on trying to find out whether it's enforceable or not. And that's on the assumption that you haven't just given your private key to your kids to make sure that, it's safe on the moment you pass away. All of that to say that between Alia and I and Basim, it's probably quite likely that you're just scratching your heads thinking, gosh, how do I even navigate all this? That's exactly why we're here. We take a bespoke, specific issue and provide the best structuring solution available. Again, perfection is often the enemy of trying to get things efficiently right. In shifting sands, just making sure you have folks around you that can act as your consigliere to make sure that you feel that you have a good view over what happens next is in itself, at least from my perspective and my experience, relatively priceless. So I guess that's a very, very quick run through how we would approach things from a UAE perspective, clicking into the home jurisdictions. And yeah, I expect if there's a number of questions, we can field that. But that's it from my end.
Thank you so much, Ali. And yes, it is a complex process, and it's not just the process; it's the actual strategy. And you and I have been involved in a few situations in the past, and firsthand how complex and how many professionals, even beyond us, we have to reach out to achieve what might seem to be a simple question our clients have. But estate planning is a complex, and it requires the legal compliance in multi-jurisdictions. So here we have Alia on the Canadian side, we have Ali on the UAE side and the UK side. Tax efficiency, because if we don't plan properly, a lot of taxes will erode the wealth, and little things that if we pivot, like Alia mentioned to us earlier, the executor who is living here in the UAE, but my assets are in Canada, this might, CRA in Canada might look at things a little differently, or from a Sharia standpoint, the opposite direction here. So you're surrounded with professionals, and we're here to help you and protect your assets and your strategy. And on that note, final thoughts on our next step. Again, the estate planning evolves as your financial situation changes. Today, I'm here. I have my children. A few years down the road, my children became adults, and so that will require that I go back and take a look at the original plan that I set up. Because when I set up, my kids were minors. The structure now has to look different because now they are adults. Review your wills and financial plan with the professionals. Ensure tax-efficient assets, structuring for smooth inheritance. And on that note, we'll come to the end of our presentation. And here in front of you, this is the team of professionals. This is the team that will be helping you every step of the way. Someone not here with us today, She was with us last month, Ruby Sean, and she is our advisor on the tax side. So the four of us, and next month there will be a mortgage specialist with us. Will be the five of us. We're here to help you. And now I'll open it for questions. I have one question that's been posted, and this is for Alia. And Alia, the question is about. So the question goes like this. Oh, Ali, you already answered it. Sorry, I didn't realize that. All right, so I'll share it with everybody. So someone asked that can you explain Quebec? Because I know that we have someone also here from Quebec. Can you explain Quebec will under civil law versus rest of Canada common law? Does it have an impact for Quebecois expats in the UAE? And Alia said wills are handled in Canada on a province by province basis. You would need to ensure any will satisfies the Quebec legislation. The withholding taxes for non-resident states is Canada-wide. So this is the question that we have now. We'll go back to the questions that were submitted to us prior to the webinar. And as I mentioned earlier, some of them, or most of them, as a matter of fact, they are of private of nature. So Ali will help us out, and we'll take a few that we can address here. Ali?
Yes. If we're
While
looking
he's
for,
looking at the questions, why don't we do this? Why don't you pick a question and I'll just add a little bit to my answer while you're picking a question there.
Okay, go ahead. So Ali.
So I appreciate the question about Quebec because it gives light to one of the other complexities here in Canada. There's a division of law between the country law and each province's law. And when you're dealing with estate planning, you're dealing with both because the provincial laws govern wills and probate, and the federal laws, which is the country's laws, govern the taxes and what happens with wealth transfer in terms of taxes. So you need to speak to a lawyer who knows both. Okay. So, because you're going to have to satisfy the provincial legislation to make sure that the actual documentation is correct, but then you're going to have to satisfy the federal laws to make sure that you have avoided taxes in the best way that you can. And Ali, I hope I gave you enough time to pick a tantalizing question for us.
I have a question that's slightly different from the tax questions, which I think is a very interesting human question. How do you make our kids safe in case of death? So this is going all
Well,
outside
it's going to
of
depend.
will, trust,
Yeah.
probate. This is to do with kids, guardianship.
So it's going to depend on the age of the kids. And we're speaking to people who are, I'm assuming, all living out in the UAE. So it's also going to depend on what your plan is. So do you want guardianship? Are the guardians resident in Canada? Are the guardians resident somewhere else? Do we need to transfer wealth to the guardians so that they have it available to take care of the kids? Do we want a portion available to the guardians and then a portion waiting for the children when they turn a certain age? These are all the kind of questions that we would start to think of when we're leaving young kids. Are the kids 18 and wild? So we don't want them to get all the money into their hands, even though they can legally get it. They're gonna spend it partying or spend it on a really nice car, and we don't want an 18-year-old to have some fancy cars. We want them to hit 25, 26, 27, and then get the money into their hands when they can make a little bit better decisions. Or maybe we put a little bit of money into their hands when they're 18 and some more when they get older. So these are all the things that we would start to consider when we're considering maybe an unfortunate situation where we depart this world and leave some maybe young or wild children behind.
Then from a
There's
UAE
some more.
perspective,
Go
sorry,
ahead.
Ali, go ahead.
No, you go ahead.
From a UAE perspective, again, I'm going to focus on this from a non-Muslim perspective. I think for Muslims, it's a slightly different scenario. But from a non-Muslim perspective, You can register your will in the DIFC to include who your guardians are. You state quite specifically who they are and the roles and the rights that they have. There's a specific guardianship will that they've even templated at the DIFC, so that you're sure that it has all the provisions necessary. I might just sort of explain exactly what happens when you're registering the will. The draft of the will is something that we'd help you with, and then it's submitted to the registrar at the DIFC. The registrar does an initial check and looks through it and says, okay, does it fulfill all the criteria? If there's bits that need changing or questioning, etc., because they need to make sure it's clear, then they'll have back and forth, usually with the lawyers, until such time as the lawyers say, okay, well, here is the version of this that we are sure the registrar is okay with, and that we think reflects your will. Are you okay with it? You'll read it. You'll go, yep, cool. So that's submitted. You'll then get a registration date, and just to let you know, DIFC registration dates and times at the moment are in high demand. I hope they increase more slots, but at the moment it's useful to expect that it'll take a while to get a registration slot. And at that registration event, you'll need to have witnesses. Andre and I tend to act as the witnesses there on behalf of AS Legal, to witness that the will has been sort of drafted and signed in front of the registrar. This all happens online, so it all happens virtually. You'll be sent an OTP with a login detail. So even if you're outside of the UAE, so long as you have a phone number or an email address, you can give them. You'll get the OTP to join the video link, and then it all happens in front of you. The registrar just, reads through the will, says, "Do you agree with the terms of this will?" You'll go, "Yes." The witnesses will say, "We're here, we're witnessing this happening," and then boom, there it happens, and the will is registered with the wills registrar in the DIFC. You'll then ask to get a copy sent to you, and you'll have a copy with you. The nuances of whether that entails wet ink in jurisdictions that need wet ink is something that we haven't seen been an issue in the past. However, one has to always be prepared for somebody to raise that. The equivalent thereof is to be able to say, this has been officially signed by the registrar of the United Arab Emirates. But all that to say that then will also include the provisions of guardianship. So if your children are of a certain age, let's say they're over 18, but they're under 21, and so therefore you want provisions from a Canadian point of view to say that, okay, we want guardians XYZ, that should be reflected in the UAE will, such there's no discrepancy between the two, even though the Asian majority in the UAE is 21. It just allows for an alignment of intentions to happen. Is there anything else you want to add on that, Alia, or do you have time for another question?
Well, actually, I have questions been posted here, and
Okay.
I think this one is for you, Ali. Is there any disadvantages or pitfalls of registering a more simplistic will with the Abu Dhabi Family Court, where there is a short-term intent to ensure a female spouse and children residing in UAE are looked after, given issues of access to funds, bank accounts, guardianship of non-Muslims?
If you're looking at getting something very quickly in there to be able to get some protections, the most important thing is then if you do some work afterwards and want to have a different will or want things to work in a different way, one of the terms of any will that, let's say you then go ahead and register at the DIFC, will be a declaration that this is your last will and testament, and any previous wills have been essentially cancelled, right? The downside of that is in the future, if there's any discrepancy between which will suffices, your executors need to be very aware that there may have been two wills in two different jurisdictions of the UAE, and that the DIFC one applies, and that the DIFC will is the one that executors need to go to in order to be able to manage the estate. And if there's any beneficiaries that would have had a better deal with the ADGM one compared to the DIFC one, they may throw a fuss, and that will lead to a dispute potentially. It depends on factoring that in and whether that's a likelihood. There is an administrative benefit, of course, that God forbid if anything were to happen to you and you need to have something there in place, you've at least got this thing to say, okay, well, this gives a right to my wife to manage the bank accounts, etc., etc. What I would say on top of that is for non-Muslims in particular, if you're looking to get something quickly, just check whether the Sharia intestacy rules actually suffice, right? Where there is a reality under Sharia that your spouse will get a certain portion if there are kids, a certain different portion if there aren't any kids. If there is no if there are no kids, then there's siblings and parents, and there's a whole sort of rule book of what happens in certain circumstances, much like Alia mentioned. And so you'd have to look at it to say, okay, well, if something were to happen, would intestacy suffice essentially? And if it were to suffice, is it worth having the complexity of one will here when I might have an intention for a different will in a different format further down the line to avoid any complication that might exist between those two particular wills? You might have been looking for a yes or no answer, and I'm afraid I can't give that.
Yeah,
But hopefully I
not in this world, unfortunately not.
no,
All right,
no.
so I'm gonna jump in. I have two more questions. That one is for Alia. Does Canadian law for asset distribution based on statute mentioned apply to assets sitting in other countries? Does residency matter in Canadian law applying?
Okay. I'm going to address one thing that Ali mentioned. It's a little different in Canada, so I thought it would be worth mentioning. So, Muslims and non-Muslims alike, the succession law reform applies. That was that structure that I was telling you. If you have a spouse, they get this much, your kids get this much. Like, so the structure that's in place if there is no will, okay? Even if you're okay with that structure in Canada, my recommendation is to get a will anyways. Why? Because over here, you require a certificate of appointment for an executor before anything can be done. You have no access to funds. You can't sell property. Like you cannot do anything. No steps can be taken whatsoever without this document. The backlog in the courts to obtain this document is insane. There is an insane backlog over here, okay? And to obtain that document without a will, the backlog is even longer. So essentially, there's a pile of paper on the judge's desk. And when the paper comes in and it says no will, they put it on the bottom of the list. And when the paper comes in and it says with a will, they put it on the top of the list. And you want to be on the top of the list. You do not want to be on the bottom of that list. You will be waiting over a year for that document. I just did one not too long ago, and we waited 18 months to get the document. So I would say, even if you're okay with the structure, you need a will in Canada just to avoid that wait. Okay. It's worth it. So, does Canadian law for asset distribution apply to assets sitting in other countries? The short answer is no. Actually, there can be a yes and a no here, although it does apply. There are exceptions, okay? It depends on, is it an income generating asset? Where is the income from the asset going to? Who is it going to? So there are some nuanced complications that may bring the asset into Canadian jurisdiction, but for the most part, when someone passes away and they own assets in foreign jurisdictions, typically they are dealt with through instruments in those foreign jurisdictions, being whatever transfer plan was there and also whatever structure is there in that foreign jurisdiction as well.
All right. Thank you, Alia. So this question, I know it can go Canada, UAE. I'm just going to put it out there, but I think Ali, this one is for you. We can work on both of them. When are trusts used versus corporations? Are these structures kept offshore?
Sure. Okay. The last word in that, offshore, to address first, from a UAE perspective, we use onshore and offshore very liberally. right? So, there's times where the UAE itself is thought to be offshore. There's times when the UAE is onshore, but the DIFC is offshore, etc., etc. So, um, a trust is a common law instrument, right? It is something which rarely exists in the same way as we're used to in civil code jurisdictions. And the UAE onshore, apart from the DIFC and the ADGM, is an onshore jurisdiction. It operates like Napoleonic code law, not too dissimilar. I'm not a Quebecan lawyer, but I think it's not too dissimilar. And so therefore you have the same conflicts of laws sometimes between civil code and the common law, the DIFC and the ADGM. Most trusts that are built for cost reasons mainly tend not to be built for family management purposes in the ADGM or the DIFC. They're increasingly, being looked at for that, and the DIFC and ADGM are trying to get people to do that, especially for big family offices. But often these trusts are built in some of those jurisdictions like Guernsey, Jersey, and other common law jurisdictions where it makes sense, and where you have a relationship often with the trustees. And so that's the important word. What are trustees? What are corporations? A corporation, often enough, is subject to corporate tax, right? So in various jurisdictions, why wouldn't you put this into a corporate sort of environment? Because corporations aren't really designed to hold assets in the same way. They are designed to be operating entities. And so those who are in leadership and have fiduciary duties, or as directors, have duties specifically for the benefit of the company. A trustee of a trust is engaged because their role is for the benefit of the beneficiaries of the trust. The trust contains assets and it's holding it in trust for the beneficiaries. So that's why trusts tend to be used for these circumstances. The actual capacity for trustees of a trust to be able to do things with those assets are very, very limited to the trust deed, i.e. the document that defines the powers of the trustees. Whereas if you have directors of a corporation, they get a lot more power to do stuff with that, and you've got the added element of corporate tax there. So that's why you've got trusts used in this environment quite a bit. I could give a lecture on this, but I won't because that's going to bore people to death. But that's a short answer.
Thank you. Thanks, Ali. All right. Well, that will bring us to the end of this month webinar. Thank you very much. And once again, for the questions that were submitted to us prior to the webinar and have not been answered, please feel free or just let us know that we will get in touch with you as soon as possible. By tomorrow, you will receive in your email the post-webinar survey. Would appreciate your reply, and don't forget to download your estate planning checklist. And thank you very much. And I'd like to thank Alia, Ali, and well, Andre, who's not here with us today. Thank you very much, everyone, and have a good evening. And good day, Ali.
Good night, everybody.
Good night.
Good night, everyone.
Good night.